Here is your 100-point question. Remember, you have to maintain it yourself in your mind. Here we go. This is the next critical date for FLSA overtime litigation in the Fifth Circuit. I should have gotten some music. Give you a minute to think about it. What is June 30th, 2017. Now, you've all probably heard about this, right? There was this litigation. We all went crazy, right? Last year, we were thinking to ourselves, oh my God, what do we need to do? We have to make sure that we get everything done before the bomb drops, the world ends, and overtime as we know it is changed forever. And then we kindly had a court that decided, not so quick. By the way, the best part about that is the clients that come to you a week beforehand and want you to do all this stuff in a week, and then a day before they're like, yeah, no. Just saying. Here's the interesting part about this. This date is important, but there's a really big asterisk. Why? Well, if you haven't noticed, we have a different president now, and we now have a new Secretary of Labor, and Secretary Acosta recently said that they're going to be putting out an RFI, which basically is a request for information from all of us, asking us, hey, listen, what do you think needs to change? So, for example, what are some of the things we were concerned about that we advocated for SHRM up on the Hill about? Things like what it's going to do to nonprofits, what happens to small businesses, how quickly is the accelerator working? All those kinds of things are on the table. And frankly, everything is on the table, which is a very good thing for all of us. Who knows what's going to happen? I would encourage all of you, once that comes out, to tell everyone you know to make sure they send in a comment. Last time around, over 300,000 comments. Imagine what we can do together to effectuate positive change. Not the $42,000 kind of change, maybe the $30-something thousand kind of change that we might be able to better live with. Okay, now, let's keep going. Your 200-point question. This is the time that employees are waiting to be called into work. All right. What is on-call time? Now, mind you, I'm not talking about when the obstetrician is waiting for the time, as it were. All right? Remember, we're in the age of technology now. This question comes out of, I know you'd be surprised, I actually tried to use it the other day here in New Orleans. It didn't work. But I did try my first Uber, which ended up not being my first because it didn't work. But the deal is this. Uber drivers, if you didn't know, log into the app so that people know that they're there. And then from being on call, then they get selected by whoever to go and pick them up and take them somewhere. So they turned and sued saying, well, wait a second, all that on-call time, you owe me money for that. Now, it raises a very interesting question because what is on-call time is sort of this big unknown right now. Technology is moving faster than the law can keep up, and frankly, it remains to be seen where this ends up. Why do you care? Well, ladies and gentlemen, the more mobile you do things, the more telework that you do, imagine the challenge. Imagine all the time, the de minimis time we talk about, are you answering emails at 3 o'clock in the morning? Only this time, it's how much time is being spent while you're actually waiting to do your job. Things to think about. But wait, there's more because I've got a 300-point question for you. I know you're all riveted, so hang on. Here we go. Unlike previous precedent, these types of damages, like anxiety and sleepless nights, are now available via retaliation claims under the FLSA. Everyone's thinking, I can see the smoke. Okay. What are emotional damages? Now, I know what you're thinking. You're thinking, well, wait, emotional damages weren't actually available before, but they are under the retaliation sections of the Fair Labor Standards Act. This actually comes out of a case out of New York where they had a husband and wife that lived in an apartment complex, and he was the maintenance guy. And so what happens? He gets a reduced rent because he's working for them, doing their thing, no big deal, isn't this great? Only he tells his employer, you know, you've shorted me on some time, I need some more overtime because our times don't work out. Your records and my records aren't the same. So he files an action. Obviously, the employer didn't pay it. But the employer did something interesting, because they turned around and said, au contraire, mon frère, we would like you to pay us for rent you haven't paid us. Now, I know what you're thinking. Which number exceeded? Well, here was the nefarious part. The amount of back rent just happened to equate identically to the amount of overtime he requested. Just saying. Needless to say, he brings this action. At the trial level, they decide, well, no, you can't talk about emotional damages. You can't have that. They don't charge the jury with any of that. Case goes up on appeal, and the court says, well, hold it. You can't do that. You actually have to take the time, send it back down. The jury should have been allowed to figure out, well, geez, did he provide enough information relative to his emotional damages such that he could have also collected for that? Now, I don't want to sound silly, but let's be honest. You know those kinds of damages, right? We got kicked out of our apartment because we live where I work, and so I didn't know where my family was going to live. So there were marital challenges, and there were other issues that existed because of what they did to me. So you can imagine how that would play to a jury if the jury instruction actually got to them. Just saying. Something to think about. Now, our 400-point question for you. Are you ready? All right. Things such as control of workers, ownership interest, general HR functions, and duration of relationship between organizations are taken into account when determining if this exists. Younger version of Alex Trebek. Okay, here we go. What is joint employer? Now, here's the crazy part about this case. This particular case comes about in the construction trade with drywallers. Originally, the case goes to district court. The claim is, of course, it's a joint employer, therefore we should be able to do our thing. Only it doesn't end up that way. Because the district judge decides, oh no. You see, this is a traditional type of environment where they are independent contractors, they're not joint employers, therefore, because historically they're not joint employers, I'm not finding that they're a joint employer in this action. That's, by the way, an interesting argument. I've never heard it actually written down in a case before. So, of course, it goes up on appeal. What happens? They're sitting there, they're talking about, trying to figure out what to do. Court says, well, hold on a second. Skip the fact that traditionally it was or was not a joint employer type of a deal. Take a look at what actually happened. So you have a drywall company that is sending guys onto a general contractor's site. They go to the site, they wear the general contractor's hard hats. They report to the general contractor supervisors. The general contractor maintains the payroll records. General contractor handles all the workers' comp payments. Do I need to go on? Court turns around and says, last time we checked, all these factors, this is a joint employer. Little things that you just cannot make up. All right. Final Jeopardy, ladies and gentlemen. This is the fun part. Now, I want to give you a hint because there's a plethora of opportunity here for the kinds of things we could be doing, right? So, here is your hint. Gig economy. Maybe you've heard of it. Small little thing, kind of exploding right now. And your question. Here we go. In the newest work relationship, individuals are no longer working for one employer for 30 years. Instead, many pick and choose how and when to work, which often leaves them considered as this. What is independent contractors? Now, I know what you're thinking. Well, but wait, Lewis, I bet all my money, where's my prize? Well, hold on, I'm not done yet. So here's the story. This case is actually very interesting out of the Second Circuit. Turns out, maybe you've taken one of these at some point, you know, not the cabs that just knock you right off the curb, but the black town cars that drive folks all over Manhattan and those kind of places. So the deal is this. When you go to work for one of those organizations, you have a choice. You can rent the car, or you can buy the car. And if you buy the car, it's much more entrepreneurial in nature. So the deal is you spend somewhere between 65 and 90 grand for the car. You're responsible for the gas, the maintenance, the cleaning. But wait, there's more. Because you're also responsible for deciding how much of this stuff you're going to take. Now, by that what I mean is, when you originally enter into the agreement, what happens is you select the level that you want to buy in. So for some folks, they would get, for example, pick your company, all the driving for that particular company within a particular window of time. Anybody that needs a driver, they would send you the call, and you can decide whether or not you actually want to take that. Now, the challenge is you don't have to. You can even decide, well, you don't necessarily want to work for one company. You want to freelance for somebody else. You pick how long you want to work. You pick how many hours you want to work. Who knows? You might decide you want multiple vehicles and have a whole bunch of people work for you. So these folks they file an action saying, wait a second, we've done all this, we've spent all this money, but we're not really independent contractors. We're actually employees. Therefore, you owe us this boatload of overtime because we're not really independent contractors. We're captive to you. There's a funny thing about that, because usually when agreements like this are drafted, people like me do it. So we try and make sure stuff like this doesn't happen. So we list out all the crazy things you can and can't do. So the court takes a look at all this stuff. And they say, you know what? There's a challenge here. Because when you look at all the various things that you do, let's look at it. It's all independent. You decide how you want to work. You decide how often you want to work. You decide if you want to work at all. The bottom line is you get the choice. Oh, and by the way, the lion's share of the cash that comes from that fare comes right back to the driver. Court turned around and said, you're a little crazy because you're independent contractors. You can't get much more entrepreneurial. I mean, I guess if you wanted, you could pick your fast food chain. Same kind of deal. But under these specific facts, independent contractor. I will say this, for those of you that are looking to do more hiring of gig type of employees, the case is very instructive. It's a very good read. I'll tell you in a minute where you can find some more information about it. So let's recap. We've learned a couple things today. A few takeaways for you to take home. Number one, overtime regs, let's be honest. We're going to hear about the request for information, so you get to say pretty much whatever you want. It's open season on overtime. I was talking to somebody last night from Government Affairs. We had gone to dinner together. We both kind of agree that depending on the number of responses, we're probably looking at later this year, early next year, before any final anything is really coming out. So you're kind of safe for the time being. Next, remember when we talk about technology and how you're going to utilize technology within your organizations, particularly for your people, be very careful to have somebody think through it. Okay? Maybe it's worthwhile to sit down with IT and with the CFO and other folks and say, okay, how are people going to be engaging, operating, and utilizing the technology to make sure we don't have an issue prospectively as it relates to the FLSA? Next, let's be honest, the gentleman at the apartment complex, part of his issue was record keeping. I know, I'm preaching to the choir, right? We're at a SHRM conference. But still, big deal, something you want to think about. Next, you want to sit down and really think through your staffing needs. What is going on right now with the Department of Labor and how they're viewing joint employers is going to be somewhat of a moving target for the time being, but it's definitely something you want to take a look at, because if you're looking to make sure someone is an independent contractor, make sure you run through the various tests. At the same time, sometimes you just want to decide you don't want to go that route. You want to go the independent contractor route. Again, you want to go through that one step at a time. At the same time, if you want more information, you can go to kiwilive.com. The keyword is HR lawyer. You can find additional information on this case, or rather all of the cases, as well as some more stuff on misclassification that may be helpful to you. Not trying to sell you anything, just trying to provide you with additional information. If you need to reach me at any point, you are more than welcome to do that. It is great to see all of you here in New Orleans. I hope to see you again as we go around the conference. Have a great time. Thank you so much.